I'm going to be here for one case, and then I'm exiting, and then these colleagues will take over from there. But the first case we have that I'll sit through is 24-1429, Sudduth versus State. Am I saying that correctly? Sudduth? Okay. I knew I was going to mess that up. Okay, and Ms. Newell, you'll be arguing for Mr. Sudduth and Mr. Rogers for the state. So whenever you're ready, we're ready for you.
Court, Counsel. My name is Ella Newell and I represent Guy Sudduth in his appellate matters. Mr. Sudduth asks this court to reverse the district court's ruling on the motion for summary disposition and remand his case for a dismissal of counts 1 and 2 for criminal transmission of HIV. In the alternative, Mr. Sudduth asks this court to remand his case for a post-conviction relief hearing. Rhodes v. State requires retroactivity because it was a substantive change which clarified existing law and did not overrule prior authoritative precedent.
Already address whether Rhodes applies retroactively in Stevens 3.
The court did address part of that argument in Stevens 3, but critically in Stevens 3, Jimmy Stevens conceded that there was not retroactivity and argued for an equal protection due process argument, and we are not conceding that retroactivity, we are arguing that retroactivity applies under substantive law. In Gooseman v. State, the Iowa Supreme Court explained there are two types of new rules for substantive law. The new rule can either clarify ambiguities in existing law or change substantive law by overruling prior authoritative precedent on the same substantive issue. So when a new rule of substantive law clarifies existing law, this requires retroactive application, whereas when a new rule overrules prior authoritative precedent, that requires prospective application. The Iowa Supreme Court clarified two aspects of Iowa Code Section 709C, which was the definition of possible as used for intimate contact and the use of judicial notice for cases involving pleas. In Keene, the Iowa Supreme Court held intimate contact meant the transmission of HIV from the HIV-positive person to the HIV-negative person was possible considering the circumstances. Keene held lower courts could take judicial notice that HIV may be transmitted through contact from an HIV-positive person's blood, semen, or vaginal fluid, and that sexual intercourse is one of the most common methods of passing the virus.
Okay. So let me just quick ask. The Sudduth's expert had testified that it was highly unlikely that Sudduth was capable of transmitting HIV to the victims, but how does that play into the word is possible? It doesn't have anything to do necessarily with likely, highly unlikely, etc.
So Sudduth's expert, the medical expert, never formally testified. We have the report. Again, this was partially on summary disposition, but that was in reference to the anal sex that was a component of that. Within the report, the expert is very clear that HIV cannot be transmitted through oral sex, where the HIV-positive person is performing oral sex on the HIV-negative person, which was the case in Rhodes and is also the case in the facts at hand for at least for one count completely and then for one part of the factual basis for count 1. And so because it was entirely, it was impossible for him to transmit HIV for count 2. And so the count 1 in the expert's report, I'd also like to note, there's only one of the minors mentioned within that report, and that's John Doe number 1 or BK. And so again, because it was not possible for John Doe 2 to have, transmission was not possible for John Doe 2.
Rhodes applies. Isn't there other items in the minutes of testimony that could support the basis for the Alford pleas besides that generic language?
No, there's not. The minutes of testimony explain that the two teenagers involved in this said, "I don't know." I mean, they told officers what they recalled, and there were instances where they, made additional comments. But they said, I don't know. And this, allowing a court to sort of fill in the blanks or using I don't know as an opportunity to rewrite a potential narrative would be improper, it's speculative. And because these are pleas, anything that was not necessary for the plea agreement or admitted to cannot be considered by the court. In Rhodes, notably, the Iowa Supreme Court was presented with the first case where only a theoretical transmission of HIV could occur, and so that was part of the reason why these clarifications had to happen. The Iowa Supreme Court clarified that possible meant reasonably possible, and it could not extend to something which could only theoretically occur, where there was virtually no possibility other than, just impossible to occur. And because this was the first opportunity the court had to address an instance where that was only theoretically possible, this amounted to a clarification in existing law. The other clarification in Rhodes addressed the use of judicial notice in other HIV transmission cases. Rhodes clarified that because a fact was capable of ready determination at one point in time did not mean it was capable of judicial notice for all of time. And especially in instances where we have criminalization statutes that do heavily rely on medical science or science in general, there's going to be an inherent changing that is separate from the court due to the nature of potential medical advancements and understandings of how HIV is transmitted. And so these clarifications and acknowledgments were made in Rhodes. Keene was not formally overruled, and neither were cases where in Musser and Stevens, these cases were not overruled by the Iowa Supreme Court in Rhodes, which also supports a finding of retroactivity.
Amount of time you have left. Can you jump to your actual innocence claim? And I know it was raised below, but it appears to be a different argument on appeal than was argued before the district court. How do you think that error was preserved?
I believe that error was preserved because under illegal sentencing arguments in general, if an illegal sentencing argument is based upon the Eighth Amendment, the court in Brugger and Veal have held that the statute of limitations does not apply for matters of that nature. Additionally, because this is a civil case, it's proper for the court to look at this as an ineffective assistance of counsel claim. The record is complete as to the issue of count 2 on whether or not Mr. Sudduth could have transmitted HIV. With count 1, it's a little bit different because the medical records in Exhibit D are confusing, as the expert notes that there are comments, but there are not full results that are included. So not to say that count 1 couldn't be subject to, again, an actual innocence claim at some point, but the court doesn't have enough to rule on that at this point. But there is a sufficient basis within the record for this court to rule on the actual innocence claims in count 2, based upon ineffective assistance of counsel as well as through an illegal sentencing claim. In addition, I mean, there wasn't a factual basis to support this plea that Mr. Sudduth made under either the Rhodes standard or the Keene standard for count 2, because HIV could not have been transmitted through that oral sex contact. If Rhodes is found to be retroactive, then regarding the instance of anal sex, the consensus report on HIV transmission stated there was a 0.11% chance, meaning 11 out of 10,000 people had the chance of contracting HIV, where the HIV negative individual was the insertive partner during anal sex. And the doctor who reviewed Mr. Sudduth's medical records, there was no concrete evidence establishing that his viral load was at a level which could transmit HIV. The doctor also noted that Mr. Sudduth's CD4 count, which measures white blood cells, was not at a transmissible level at the time he was found guilty. But even if he did have a viral load at that time, 11 out of a 10,000 chance is not a realistic possibility under Rhodes to transmit HIV for someone to contract the virus. And if there are no further questions at this point, I'll be back on rebuttal.
Mr. Rogers?
Thank you. May it please the court, counsel. I'm going to start by talking about why Rhodes is not retroactive. As this court determined in Stevens 3, Rhodes changed the law. It was not a clarification. Substantive changes are not retroactive. And to the point that Stevens made a concession on federal due process, that was in favor of trying to make an Iowa constitutional due process claim, saying there's a different standard under the Iowa Constitution. The court said, no, there's not a different standard. We apply the federal standard. So for all intents and purposes, the federal claim was rejected by this court in Stevens, as well as the Iowa constitutional claim, which is the same claim. I don't know that our materials really did a good job of saying what is a clarification of substantive law. And going through Guzman back to what it cites in Fiore versus White and Bunkley versus Florida, I believe. Fiore and Bunkley, I know those names. But
Law here seems to go to the process. Like, you don't do judicial notice, you have to have an expert. So using that, tell us how this is not, or shouldn't be retroactive.
right, it's Fiore was like the first interpretation of a criminal statute. And the question was, what acts were prohibited at the time that Fiore was convicted? And so the Pennsylvania Supreme Court said, you know, these were the acts, you know, operating a hazardous materials plant without a permit was what was prohibited by that statute. And in a companion case, basically, the co-defendant's case, the Pennsylvania Supreme Court said, well, there was a permit, so it wasn't a violation of this statute. And it had already passed on taking Fiore's case, and Fiore filed another case and said, hey, this applies to me too. And the U.S. Supreme Court said, it does apply to you because this was the Pennsylvania's Supreme Court's first blush at interpreting this statute. So, okay, the clarification here is keen. That's the first blush at interpreting what is intimate contact. And so when Rhodes came along and redefined what could transmit means, that's the change. So in the Heemstra context, Beeman was the clarification that, you know, the willful injury can be the predicate to a felony murder conviction. And Heemstra was a change in that substantive law. So we have Rhodes changing that definition of what intimate contact means, and the other changes resulting are that judicial notice is improper going forward, and that expert testimony is also required to establish that HIV could be transmitted. I lost my train of thought, but so Rhodes changed the substantive law, and that's our position there. The expert below said it's highly unlikely that Sudduth could have transmitted HIV. I think under the law that applied at the time, which was Keene, highly unlikely to be able to transmit HIV still qualifies as able to transmit HIV. But the expert also did not distinguish between the anal sex and the oral sex route. Just said it was highly unlikely in the conduct that Sudduth was charged with.
Victims here, which ones can we say, okay, this dealt with anal sex in addition to oral sex?
Well, BK testified that he remembered anal sex happening, and there's a statement that Rhodes made that his preference was to be penetrated anally, and I think that's on page 55 or 56 of the minutes of testimony. And TD was the other victim who didn't remember, but woke up with his clothes askew and his pants on sideways, his boxers on sideways. He felt that something sexual had happened, and his testicles hurt. So we're not in a substantial evidence question. It's not a sufficiency evaluation we're doing. Was there a factual basis to support that? And I think that there is a factual basis to support that based on the conduct against BK, against Sudduth saying that that's his preference, and his course of conduct described a lot in the minutes that this was his every weekend he was having the teenage boys over to his apartment. He was spiking their drinks with drugs and Viagra so that he could use them this way. And
Even if, same question I posed to your opponent, if Rhodes does apply, do you think there is a sufficient basis outside of that generic language in the minutes to support?
if Rhodes applies, Rhodes had no detectable viral load, and so I think that was what was a big part of what the Iowa Supreme Court was saying. There's no factual basis, and I think that if Rhodes applies under the procedural posture we have, we go back, reopen the plea, everything comes back in, and we can try to establish that factual basis and evaluate whether that factual basis is there. I think, let's see, if Rhodes applies, then we also don't really know what reasonable possibility means based on Rhodes, except for how that court applied it to Rhodes. So if there's room in between the possibility of somebody without a viral load like Rhodes and somebody with a detectable viral load like Sudduth transmitting via oral sex, which the expert here cited the consensus report, and that consensus report said, we can make statements about anal sex and about vaginal sex, but we don't have good enough evidence to say anything conclusive about oral sex. But since we don't have that evidence, we're going to say that it can't transmit. So it's not really a great representation of all the science about what's possible and what's reasonably possible. So I think that it could go back if Rhodes were applied, and I think there is a factual basis in the minutes. To short answer to long there.
Could you also address your opponent's position about preservation of error with regard to the actual innocence claim?
Our position is that it wasn't preserved below. He made different actual innocence claims below. The actual innocence claim here is a challenge to the substantive validity of his conviction, which is basically the opposite of an illegal sentence claim. And bringing it under an illegal sentence claim would really open the door to anything being challengeable at any time. Because if the reasoning is, well, there was a problem with the conviction, so the sentence was illegal. If inadmissible evidence was submitted, is the sentence illegal? Is there a problem with the conviction because of the inadmissible evidence? So we think that the illegal sentence claim exists to remedy any court that sentences outside of its power to sentence, and this isn't a court that sentenced outside of its power. The conviction was for illegal transmission of HIV. Sentence is a Class B felony. He was sentenced to a Class B felony for that. There's not a legal sentence wrapped into there. So with my remaining time, I'll ask you to affirm the post-conviction court unless...
If there is a preservation of error issue with the actual innocence claims, should we be looking at this as ineffective assistance of counsel?
I don't think counsel has a duty to make an actual innocence claim based on an illegal sentence vehicle, because counsel doesn't have a duty to make a new claim or a meritless claim.
Please.
I think the first point I'd like to address on rebuttal is that substantive changes are retroactive. Guzman and Newell explain very clearly that in order for a new, again, there are two types of new rules of substantive law, ones that clarify and ones that fundamentally change the law. And those fundamental changes require that the elements of the offense change, like in Heemstra, or they overrule prior authoritative precedent, also like in Heemstra. And in this case, all of the elements remain the same. There were clarifications about about medical advancements, which reflected the nature of HIV transmission. And so when Keene was decided, the belief at that time was that HIV was highly transmissible and that you could use a broad generalization to fill in the gaps of a plea. And Rhodes reflects the medical understanding of that HIV transmission is a highly individualized analysis that focuses on what sexual acts occurred, what was their protection, and what was the viral load of each of the individuals involved with this. And so because HIV transmission, again, from the consensus report, it establishes that HIV is difficult to transmit through sexual contact. And I would respond that, again, the HIV consensus report is very clear that oral sex cannot transmit HIV. And that is due in part to because saliva is not a fluid which can transmit HIV. And again, if we look at the specific language of 709C, it requires a fluid which can transmit HIV. And in this case, the only fluid that my client exchanged was saliva, which fundamentally cannot transmit HIV. It actually has properties which inhibit potentially obtaining HIV or transmitting it. And that's all detailed within the consensus report.
Details, right? Because this was an Alford plea, so sometimes those are very generic, but in this case, you're indicating the victims, each act as to each victim will need to be specifically set out.
Yes. And that's due in part due to the inherent nature of how HIV is transmitted. That has nothing, to do, it's part of the intimate contact element. And that reflects the medical understanding. And so we wouldn't, once we know more about science, we're not capped to have, again, just because something was capable of judicial notice at one time does not make it capable of judicial notice for all of time. And I would also say that Schmidt, with the actual innocence claim, was based upon the Eighth Amendment. It's a fundamental principle that if someone is factually innocent of a crime and we are going to incarcerate them for that violates due process, cruel and unusual punishment under both the U.S. Constitution and the Iowa Constitutions. And so based upon that finding, illegal sentences can also be found under the Eighth Amendment or Section 17 of the Iowa Constitution as well. And so this court would have jurisdiction to address this actual innocence claim under that factual pattern. And part of the conflict with this case is that we have known for decades that saliva cannot transmit HIV. And that is part of the conflict within this case.
The victims who say, okay, there was anal sex.
So again, in this case, there was one instance where someone specifically alleged anal sex where my client was the receptive partner and the HIV presumably negative individual was the insertive partner. And so the HIV consensus report explicitly explains, even in a case where someone has a viral load, the chance of contracting HIV from that act is 11 out of 10,000 people. So that is not a realistic possibility. That would not be a realistic possibility under Rhodes. And again, there's evidence to say that my client could not have transmitted HIV. Again, the viral load count isn't, Exhibit D is just very confusing, and the expert is very clear that there's a lot of notes from people we don't know. And then I don't know how to read blood work reports, and there's no one in the record that can explain what a lot of those things mean. So I'm going to defer to the expert on that. But he explained that his white blood cell count with the CD4 was at a low enough level that it's unlikely he would be able to transmit or had a viral load, which would make it impossible for that to occur. And so that's what Rhodes held as well. Again, Rhodes ultimately is a clarification because it reflects nuances in medical understanding that are inherent to criminal cases that involve medical or scientific knowledge as a basis for a conviction.
Ms. Abt, so thank you, unless you need to sum up at all.
That that this court reverse the district court's ruling on the motion for summary disposition and remand for dismissal. Thank you.
Thank you, counsel, for the excellent arguments today and the briefing, and please consider 24-1429 submitted, and my colleagues and I will get out a ruling as soon as possible. And with that, I'll go exchange seats.